had a picture of the firm. I'm Michael Ettinger from Ettinger Law Firm, and this is our 4 advantages of using trust seminar. Thank you for joining, and please accept my apologies for the technical difficulties in this day and age. You can never rely on these things 100%. But thank you for coming. So we start with what is elder law estate planning? And it's an area of law which combines the features of elder law, which is disability planning, and estate planning, which is death planning. And, here at Ettinger Law Firm, sometimes we say planning for disability is more important than planning for death, because planning for disability is for you, planning for death naturally for others. And we're going to talk about tonight is using trust to create order out of chaos, because trust avoids these pitfalls. They save time and money in settling the estate because there's no court proceeding. They avoid legal guardianship if you become disabled. I'll get into that a little more. They keep your assets in the bloodline instead of going to in-laws. That's called the Inheritance Protection Trust. We'll talk about that. And they can protect your home and life savings from long-term care costs. That's the Medicaid Asset Protection Trust, which we're going to cover. You can ask questions during the seminar, but I will answer them at the end. Some of you sent in questions ahead of time. I'll also answer those. I'll have to run over to the printer and get them, but I'll be happy to answer them. And finally, trust, keep control in your family and out of the court system. And I'm a big fan of staying out of the court system. I've been a lawyer since 1980. It's 45 years. For the first 11 years of my practice, I was a litigation attorney. And as soon as I heard back in 1990, so 35 years ago, that if you set up a trust, you don't have to go to court to settle, I said, well, who doesn't want that? So I stopped litigating. I started my trust and estate practice in 91, 35 years ago, to keep you out of the court system, because when you go to court, who's in charge? The judge, right? Now, does the judge always act in your best interest? Of course not. Does the judge ever make a mistake? Well, of course, the judge is human. And when the judge says jump, your answer has to be what? I know you're thinking how high, but actually it's how high, Your Honor. So we don't want that. We want control over our affairs, not somebody else to have control. So we're going to talk about that too. So the first of the 4 reasons why trusts are preferred over wills is because trusts protect you from guardianship proceedings if you become disabled. Wills don't. Well, you've heard about guardianship proceedings, but you may not know all the details. So one of the drawbacks of a will is it takes effect at death. It's a plan for death. It's not a plan for what happens during your lifetime if you become incapacitated for any reason, unable to handle your legal and financial affairs. Eventually happens to half of all people. So there's no plan for what happens if you're sick, homebound, or disabled. Eventually, we all get we all get somewhere. So this happens to about half of all people. A trust takes effect while you're living, which is why it's called a living trust. And it takes care of all 3 phases of your life. Today, while you're healthy and capable, you run it yourself. Unless you're trying to protect your assets in long-term care, but you still have control over that trust. We'll talk about that. It says who you pick will take over if you become sick or disabled, and who will handle your affairs after you're gone, your executor. So we talked about the chance of disability, about half. Without your own plan, New York State has written a plan for you. That's why it's so important to have a plan, because the state's plan is to appoint a legal guardian if you can't handle your affairs because you don't have a plan. And you may have given someone a power of attorney, but surprising to most people, power of attorney does not prevent a guardianship proceeding, because the judge can cancel your power of attorney, put somebody else in charge. Now, how and why would they do that? Well, it happens all the time. Let's say you're in a nursing home. Well, the nursing home wants to make sure they get paid. So they go to court and say, we want to be the legal guardian because mom or dad is living with us and it's costing a lot of money. We want to make sure we have access to the assets. And the court is very sympathetic to those types of applications. So they cancel the power of attorney you gave to somebody who you wanted in charge, and they appoint somebody else as the legal guardian. So power of attorney, very useful, don't get me wrong, but it doesn't stop a guardianship. So now the court is going to choose who your legal guardian will be. Maybe a stranger. Why is that? Well, because a lot of the judges feel your sons and daughters have a conflict. What's the conflict? If they spend it on you, it's coming out of their inheritance. So they want somebody independent. Well, the key is to stay out of a guardianship, because once you're in, it's almost impossible to get out. You got to prove to the judge you don't need it anymore, and that's going to be very, very difficult indeed. These proceedings are expensive, involving multiple hearings. They're time consuming, and they're very stressful because you don't know what's going to happen, who's going to be in charge. And also, as an elder law attorney, we specialize in protecting your assets in long-term care. One of the ways we do it is by moving assets to your children to protect them. Well, once a legal guardian is appointed, they can't move your assets to the children because that's not in your best interest. It might be in the best interest of the family, but the legal guardian has to act in your best interest, which is spend the money on you till there's nothing left. Now, people will say, sticklers, that yes, the legal guardian can go to court and ask the judge for permission to transfer and protect assets. But I've been there, and I had a case where the legal guardian made the application. Sometimes they won't make the application because it's not their money. They don't really care that much about it. But I prevailed on the legal guardian to make an application to the judge to move to protect assets, and the judge turned down the application. The judge said, well, in my opinion, it's mom's money. It should be used for her care. And if there's anything left, that'll go to the children. So what happened was we got the judge's values instead of the family's values because the judge was in charge. That's why I want to take control and put it back in the family. So your people do what's best for your family and not what somebody else thinks. So as I say, conflicts often arise between what the family wants and what the legal guardian wants. And who's going to win that? The legal guardian. So the key is to avoid guardianship. And the way we do that is by setting up a trust. Because unlike a will, the trust takes effect while you're living. Again, that's why they call them living trusts. And it stays in effect if and when you become disabled. But of course, you named your people in charge. Now, let's say your name is Mary Jones. So you set up the Mary Jones Trust, you appoint yourself as the trustee or manager of the trust. Now you retitle your assets from your name, Mary Jones, to Mary Jones, trustee of the Mary Jones Trust, dated whatever. You run the trust, you buy and sell, trade the same as before, you file the same income tax return as before, no limitations, you do whatever you want. But now you have a plan for disability because the trust says, if I become disabled, I name so-and-so to step in. Can be one or more than one person, can be two or three. And usually it says either of them can act. But now the persons and trust are in control instead of legal guardian and the judge. Now, I mentioned, of course, if you recover, you take back control. It's between you and your family. I mentioned a few moments ago that the judge can cancel your power of attorney. But fortunately for us, the judge can't cancel your trust. So the trust is stronger than the power of attorney, and the court cannot override your trust. So you're guaranteed to get the people you choose in the event of disability. And what do you think those people are going to do? They're going to call your elder law firm, Ettinger Law Firm, we hope, and they're going to say, this is a situation, what do we do? And we'll tell them, well, you're in charge. Fortunately, you have a good plan. These are your options, 1, 2, 3, 4, etc. Which suits you best? So they're in control. It's between them and your attorney, and they have all the options that the law allows, which are fairly extensive, and you don't need somebody's permission. Obviously, a far cry from what we just described in the guardianship proceeding. So we'd like trusts avoid guardianship. That's number one. Trusts prevent guardianship from happening, and you get your people in charge. A word about the power of attorney. Not all powers of attorney are created equal. I wrote a chapter in my book on this. So the elder law power of attorney, this one is prescription strength. And it works just like medicine. What if you only have over-the-counter medicine and you need prescription strength? You know what happens? It doesn't work. It's not strong enough. Same thing, the standard form power of attorney, the one issued by the state of New York that almost all lawyers use, well, it's over-the-counter medicine. But as you get older, you need prescription strength. And here's what I'm getting at. When you get older and you run into a health situation, you may need to transfer assets to protect them. The standard form allows your family to make gifts up to $5,000 a year. Well, gee, in 3 years, you'll be able to save $15,000. Meantime, the nursing home's costing over $20,000 a month. So you're spending 200, you know, 240,000, 250,000 a year, and you could save five. So this elder law power of attorney doesn't have a limitation on the amount of gifts. And I want to explain something about Medicaid law. If you're on the nursing home doorstep, let's say I have 500,000, I can save 250,000 by moving it to the children. So we gift 250,000 to the children. As long as we spend the other 250,000 on your care, we can save half. That's if you did no planning. I can still save half, but the key is I have to be able to move the money. If you can't move it, you lose it. You know, under Medicaid, move it or lose it. Well, if your power of attorney only allows you to move five, you're sunk. But if you have an elder law power of attorney, they can move any amount. If it's 250,000, they can move 250,000. So we do this to be able to protect assets later in life. Again, unless you have that unlimited, we call it the unlimited gifting power. That's the key to allowing half the assets to be protected on the nursing home doorstep. That's in our elder law power of attorney, which you only get from an elder law firm. Reason number two, that trusts are preferred over wills or trusts have advantage over wills. Trusts protect you from probate court proceedings on death. Well, wills don't do that. All wills have to go to court to be probated because probate means to prove the will is valid. So yes, you had your witnesses, it was notarized, it was supervised by a lawyer, but still, proof has to be made in court that at the time of signing the will, you're of sound mind, memory, and understanding. You were not under any fraud or undue influence. You were able to read and write, converse in the English language. A couple of other proofs. So we have to go and file that proceeding. Now the court has control over the estate. We have to wait for the judge to rule. And the executor cannot act until approved by the judge. This can take a long time, sometimes a couple of years, causing enormous delays in getting access to money and other assets. So imagine that. Can't get access to money. The stock portfolio can't trade. You can't, if it's a rising market, you can't take advantage of it. And if it's a falling market, you can't get out. This can be costly depending on the complexity of it. It's a court proceeding. I mean, that's why I got out of litigation, because who wants to go to court if they don't have to? You know, it's very up in the air. How much it's going to cost depends on what the judge wants. It depends on the complexity of the matter. It depends on proofs. It depends on the availability of witnesses. It can be time consuming. And again, it's stressful. Why? Because you don't know how long it's going to take. You don't know how much it's going to cost. Not only that, but the will is public record. Anybody can go down and see how much you had, who you left it to, including where they live. It's right in the probate petition. People crave privacy today. So the trust avoids the probate court proceeding entirely for trust assets. Those are key words there, entirely for trust assets. So not only is it enough to set up the trust, but the law firm has to be diligent in making sure that the assets get into the trust. Now, we have 35 years experience doing nothing but this. So we have mastered the ability to get the assets into the trust. Not only have we mastered the ability, but we actually care that it gets done. So we see to it it gets done. All of our trusts are properly funded. We do it for you. We contact your financial advisors. We give you the paperwork to take to the bank. We do all your deeds. So we make sure it gets done. We're careful about that. We care about it. So you're going to save a lot of time, and time is valuable. You're going to save a lot of legal fees and court costs not having to go to court. You know, for people, it can be tens of thousands of dollars, and for many people, hundreds of thousands. But the main thing is you have control, your family has control. It's done very quickly. We don't need anybody's permission. So on death, the backup trustee can act immediately without the need for a court appointment. I'll tell you what it takes. It takes 2 weeks to get the death certificate, because we need the death certificate to prove that the trustee is deceased, and for the backup trustee to be able to act. 2 weeks, not 2 years. So this is very, very quick. Imagine this. I mean, the difference between carrying a house empty or a co-op empty for a year or two, as opposed to being able to sell it right away. It's just an enormous difference. People love trusts because of this. Not only that, but it's private. Because it doesn't get filed in court, nobody can look up how much you had, who you left it to, who you left out. Only people named the trust get to see it. So if you're leaving somebody out, or you're leaving them less than they think they're entitled to, nobody's going to have a problem with it. It's very, very hard to contest the trust. First of all, you don't know what the assets are. You don't know who are getting them. And lawyers don't like to go after trusts, because judges feel if you did a trust, you're probably fairly sophisticated. You knew what you were doing. And not only that, but there's a procedural problem in that nothing prevents the trustee from distributing the assets to the heirs. So if you sue a trust, you got to run after the heirs. It's like, closing the barn door after the horses are gone. It just doesn't work. Challenging a will is easy, because when you challenge a will, the judge, it's in court. So the judge says, hold on, nobody gets anything until this is decided. So if somebody wants to challenge the will, they have an advantage. Nobody gets anything until they deal with the challenger. Trusts are not like that. You can't stop the trustee from distributing, but you can stop the executor in a will. So lawyers don't like to go after trusts. It can be very hard for anybody to challenge your trust. I've actually, in my 35 years, I've never had somebody successfully challenge one of our trusts. And we've done tens of thousands of them. I want you to be aware of the multiple probate problem. You have a house here in New York, a rather modest looking place, and one of these pastel colored condos in Florida. You have to probate the will in every state where you own property. It's called the multiple probate problem. But fortunately, we can deed the property from any state into your trust here in New York and avoid these multiple probates. So you avoid probate in New York plus every other state where you own property. We do the deeds for you. We can deed from any of the 50 states. So like trusts avoid probate. We also talked about avoiding guardianship. Now, we want to talk about the third reason we prefer trusts. Trusts protect the inheritance you leave from your children's divorces, losses, and creditors. Keep your assets in the bloodline for your grandchildren. Wills don't do that. This is the Inheritance Protection Trust. I cannot tell you how popular this is. So many people have done it. Tens of thousands of clients have done them. So instead of leaving it to your son or daughter directly, you leave it to a trust. Now, why would you do that? Because they can be in charge of the trust and they can spend whatever they want. So you're not ruling from the grave. They can buy, sell, trade, spend. They can spend the whole thing. But the trust protects them if they get divorced. Well, the divorce rate's almost half. That starts to sound like a good idea, doesn't it? It protects them if they get sued. I mean, people get sued for all kinds of things today. We live in a litigation-happy society, and creditors. But the main thing is, without the trust, you leave it to your daughter. She dies, it goes to her husband and wife number two. With the trust, if your daughter dies, it goes to her children. If she doesn't have children, it goes back to her brothers and sisters. So it passes by blood instead of by marriage. Everybody wants this. It's the most popular thing. Now, some people say, oh, my will says that. My will says it goes to my daughter if something happens to her, to her children. No, actually, it says I leave it to my daughter. And if my daughter dies before me, the key words are before me. If she predeceases me, what I was going to leave her, I'll leave to the kids. That's not what I'm talking about. What I'm talking about is your daughter doesn't die before you. She survives you. She gets the assets. You don't have control over what happens after that. It's likely going to her husband if she dies, because your estate is closed. It doesn't go to her kids only if she died before you. If she dies after you, it's hers, and then it's her estate, right? Goes according to her plan. So by setting up a trust, you can overcome that, and you could say in the trust, I'm putting you in charge, Mary. You can do whatever you want with the money, But this trust says whatever you spend goes to your kids. And if you don't have kids, it goes to your brother and sister. So you can keep it in the blood. She can't do that herself, but you can do it for her. You can also use trust to protect against the beneficiaries themselves. So they may be spendthrifts, they may have special needs, they may be learning disabled, they may be a soft touch, they may be spendthrift, they may have a spouse that controls them. I know some people listening have a son-in-law or daughter-in-law who's controlling of your son or daughter, and you don't want them having control over your money. So in that case, you could put somebody else in charge or have a co-trustee. These are the types of things we talk about in the consultation. At Ettinger Law Firm, we like to say we do the social work first and then the legal. So we're going to interview you about your family, your children, your son-in-laws, daughter-in-laws. Do you like them? You don't like them? What are the issues? Who doesn't get along with who? And why? This really helps make a better estate plan. When you know what the social problems are, you can actually draft an estate plan that instead of tearing the family apart, it will keep them together. It makes a difference. It's one of my critiques of the profession that estate planning lawyers are not taught. They're taught the law, but they're not taught that it's actually a social exercise, and you have to do the social work first, and the legal should follow and serve the social. Too many lawyers, they put the law first, and they prepare a perfectly legal estate plan that tears the family apart after the parents are gone. So we're very conscious of keeping the family together, doing no harm. We don't want to do harm with the estate plan. Because if you do harm with an estate plan, you can't fix it, right? It's too late. It lasts a lifetime. So now I'm going to move my picture out of here. Here we have our family. There's Bob and Mary and the kids and, grandma and grandpa. Okay. So let's say where this is Mary's estate. On her death, because it's in the married trust, it goes to her children. Okay, very nice. Who's in charge for the kids? One of Mary's brothers and sisters, or whoever you pick, are in charge. They use the money for their health, education, maintenance, and support. Generally, we say until age 35, but you can pick another age. And whatever they didn't spend on them, they turn over at age 35. Again, if they didn't have children, to go back to brothers and sisters, then nieces and nephews, but your grandchildren. Okay. Now, some people are very fond of their son-in-law or daughter-in-law. In fact, some clients are fonder of their son-in-law or daughter-in-law than they are of their son or daughter. But that's what happens when you meet with enough people, you see everything. But you could say, you know what, if when Mary dies, she's still married to Bobby, and they're cohabitating. People could be married but living apart. So they're married, they're living together. She unfortunately dies first. You could say, you know what, I really like Bobby. So I'm going to give half to the grandkids at that time. I'm going to leave half in trust for Bobby, give him the income for life, and then when he dies, give the second half to the grandchildren. So now Bobby gets remarried. Wife number two doesn't get it because in a trust for Bobby, controlled by another of your family members, giving him an income. And the grandkids still get it, just in 2 installments. What this means is your careful planning continues for decades after your lifetime. You know what? These estate plans actually turn you into the hero. You're the hero because you planned it, you took care of everybody, you stayed in the family, you protected your assets from long-term care, you avoided court proceedings on death. Makes a huge difference to the family, and they'll really appreciate what you did for them. Now we talk about asset protection with the MAPT, the famous Medicaid Asset Protection Trust. So number 3, reason to use trust to keep it in the bloodline, but number 4, protect your home and life savings from long-term care costs. Wills obviously don't do this because by the time you get to the will, you're deceased, and you may have lost everything already to long-term care. So this is while you're living. We're going to place your home and certain assets into the MAPT and qualify you for Medicaid benefits. This is a middle-class entitlement. So the trust sets up 3 roadblocks that Medicaid can't break through. Now, it's called an irrevocable trust, but before you head for the hills because you're afraid of the word irrevocable, you're going to learn that an irrevocable trust in New York is irrevocable only because you can't revoke it yourself. But we have another rule on the books that says that if every person named in an irrevocable trust agrees in writing that they no longer want the trust, you may revoke it on the written consent of all the named parties. We're all named parties, you and your children, everybody signs, you can undo it. Actually, it's even better than that, because when you set up the Medicaid trust, you reserve the right to change who's in charge. And you also reserve the right to change who you leave it to. So if one of them won't sign, you can actually take them out of the trust. They're no longer a party, and then you just have everybody else sign to undo it. So all of this is to say you have complete control of this. You can change who's in charge. You can change who you leave it to. You can revoke it. Just have to have everybody sign. Somebody won't sign, you take them out. Then the rest of them have to sign it. That one doesn't have to sign. So you name somebody as trustee, usually one or more of the adult children, and these are called income-only trusts. You only take the income. You have CDs, you get the interest. Stocks, you get the dividends. But the trust doesn't affect your lifestyle because you still receive all your income. Your Social Security, your IRA distributions, your pensions, your interest, your dividends. And most people living on their income doesn't affect their lifestyle. This makes sense for assets you're not going to spend, like your home. You're not going to spend the home, so protect it. It's your most valuable asset for most of us. And if you have investments you're just taking income from, or you're not even just reinvesting it, the trust will give you the income. And if you don't want the income, the trust will reinvest it. But if you have a nest egg that you don't need, well, you're actually safe keeping it for the long-term care industry. Doesn't it make more sense to put in the trust, still there if you need it, somebody else can come and take it away from you? So you put in the house, you have exclusive right to live there, you enjoy the property, like life rights, life estate. You keep your star, your veterans, all your exemptions, senior star, whatever you have. And you have control. There's my favorite word, control of your trust, because you reserve the right to change the trustees at any time. Which means what? That's going to keep them honest, right? You can fire them. At the end of the day, if you're only getting the income, Medicaid can only get the income. The nest egg is protected for your family. More about the trust. Trust can sell the house and trade stock. So almost every day, people come in and tell me the strangest things that they heard, and often from professional advisors. They'll say, well, my financial advisor said that, if I put my house in irrevocable trust, I can't sell it. Oh, really? I would say we've done that quite a few thousand times. No such rule. They'll say, well, you don't control it. You can't do trades. Yes, you can. All you have to do, and we do this all the time, the trustee signs what's called the third-party authorization. I authorize mom or dad to trade on the account. You continue trading. If it's online, they give you the PIN. You just log in with the PIN, no problem. These trusts are very flexible. Some of you may know I write a newspaper column in 13 newspapers across New York. Been writing it for a few years. And I wrote a column a few months ago. I entitled it, "When it comes to elder law estate planning, there's more misinformation than information." So when you go on the internet, you get a longer incorrect information, or it's correct, but it doesn't apply to New York. There's all kinds of, there's probably 100 different types of irrevocable trust. So people read about one irrevocable trust, but it has nothing to do with this one. So this is a very specialized type of irrevocable trust. I've written 3 books on this subject, and I have a new book out, 2025 edition, which you'll see at the end. But my book is on Amazon. All other attorneys read it. Law students read it. It's plain English, and it's been vetted. It's my 3rd book since 2010, and nobody has found any mistakes in it. So it's a good resource. When you come to us, you get the correct information. Very hard to find these days. So there's a 5-year look back for facility care, nursing home, possibly a new 2.5-year look back for home care. Now, they keep raising it, never passed, and it's not on the agenda for this year, may never happen. So currently there's no look back for home care. Put your assets in the trust. Of course, you have to need home care to apply. But if you need home care, we put the assets in the trust. Next month we apply, you're good. You'll get the benefit. Now, I said it's an income-only trust, but let's say you need let's say you need $50,000 from the trust to take your whole family and your lawyer to Disney World. Well, you can't take out the 50,000, but you make a gift of 50,000 to your children. They can't give it back to you, but they can spend it on you. They could pay for the trip. Because when I apply for Medicaid, they're going to ask me, what did you take out of your name and put into the trust? But they won't ask me what the trust gave to somebody else. So you tell your son or daughter trustee, you know what, take 50,000 from my trust and pay for the trip to Disney. Medicaid will never see that. They can't give it back to you because Medicaid will see it in your bank account and you're finished. So there's a way to get the money out. You can gift any amount tax-free to your children, any amount. IRAs, 401ks, other retirement plans, exempt from Medicaid. People are so surprised at this. I don't have to worry about your IRA, 401k. They can't get at it. And it's exempt from probate, isn't it? You know, it has a designated beneficiary. But what Medicaid does get is the RMDs, required minimum distributions. They get that. That's income. You got to take it, they grab it. But that's maybe 4% a year. They can't go into the IRA if you're short. That is exempt. You know, it always pays to get started because it prorates. Let's say you set up the trust. 4 years later, you have to go into nursing home. You only have to pay for 1 year. You already got 4. So it always pays to get started. So we started with the concept that estate planning with trust creates order out of chaos. Well, it does. It avoids guardianship on disability, keeping control in the family, and gives you asset protection options. In other words, the right to save at least half, sometimes more, because your family's in charge and you have that prescription strength, elder law power of attorney, they can move the assets. It avoids probate on death. Now we have control. There's that word, control in the family, saves significant time and money in settling the estate, keeps your affairs private, and who doesn't want privacy? Protects the inheritance from the children's divorces, losses, and creditors, then pass it by blood to your grandchildren instead of to in-laws and their families. Well, I know people like that. They've done tens of thousands of them. In fact, everybody we mention the Inheritance Protection Trust says, yes, that's what I want. It protects your home and life savings from long-term care costs, make you eligible for Medicaid for home care or facility care if and when you need it. So I can't emphasize enough, I can't overstate the case. To have a plan done by a capable elder law estate planning firm makes an enormous difference in your life and the lives of your loved ones. Let's talk a moment about Ettinger Law Firm's unique planning process. There's my new book, Ettinger Law. It's 300 pages, but it's big print, and you don't have to read the whole book. We'll tell you which chapters apply to you, and then you can read what you want. But the process begins with this seminar. You warm you up a little bit, get you understanding some of the concepts. I have an expression, you know, I say, if you don't understand the plan, you don't have a plan. So we're going to make sure you understand what you're doing. So we're going to invite you to a no-cost initial consultation, where I'm going to review your, well, we have 9 lawyers, myself or one of my lovely wife and law partner, Suzanne. We're here on the island, and I'm in White Plains, Staten Island, once in a while. But we'll review your plan if you have one. We'll tell you if it's adequate or if it's not. You know, frankly, it's rare that people have a plan that's up to speed, or they wouldn't be seeing us. But they haven't seen an elder law attorney, so they don't have the elder law power of attorney. They don't have a trust. They don't have the asset protection. We're going to look at your plan. We'll give you a copy of my book and tell you which chapters apply to you. You know, we're going to make our recommendations. This is what we think you should do and why. We'll tell you how much it'll cost. Everybody wants to know. And then we're going to ask you to go home and read the chapters we assigned you. So you can come back a couple of weeks later and have a second no-cost consultation to have your questions answered. So now this is how we're building your confidence. We consider this whole exercise a confidence building exercise. Everyone who comes to see us, well, almost everyone, is at a low level of confidence because they don't know what they don't know, and they don't want to look silly. And but we don't look at it that way at all. We know that you don't know much about estate planning. Why would you? Our job is to advise you and teach you in plain English what you need to know. And so we do that by giving the pages to read in our plain English guide. I have a video, 37 minutes, explains everything right on the website. And when you make an appointment, they actually send you a copy of the video to watch ahead of time, so you're further warmed up. So now you come for your second meeting. There's no charge. We're going to answer your questions. We're going to draft the estate plan. So that means who's your first and second choice to make medical decisions for you? Who do you want to handle your affairs if you become disabled? One person or more than one person? What's your plan of distribution? All at once or over time? Equal amounts or unequal? All the time, we're giving you advice, making recommendations, telling you what your options are. And you reach your conclusions based on what's best for you. And now we give you a detailed 3-page proposal for the fee. We mentioned the fees in the first meeting, so you know what you're in for, but now it's in writing. And then we say, well, what would you like to do? It's very low key. Now people say, well, it sounds good, let's go ahead. Now, this is something that I believe no other firm in the country does. I invented this, and it's worked very well. You don't sign anything. We don't have a retainer agreement. You don't pay any fees. Okay, this is unknown because every lawyer is trained. The way I was trained, you have the client sign an agreement, they pay you half the fee to get started and the second half when you're done. So why don't we do it that way? Well, I've been giving seminars for 35 years, and I've given, well, over 5,000 seminars. And about 10 years ago, it dawned on me that I'm giving seminars telling people all about taking back control, taking back from the courts and the government, and you're putting the family in control. And then I realized when a client comes in and hires me and gives me a check for half the fee, they've actually lost control because they don't, they have to rely on my good faith. They have to rely on the fact that they're going to be happy with what we produced. They're going to agree with it. All they get is a promise. What really happens when you hand the lawyer that check for the retainer, you've actually lost control. You have to hope the lawyer is going to perform, and you're going to hope they perform in a timely manner to your satisfaction. So I said, that doesn't make sense. What's better for the client is we sign the agreement, we're going to do it, and the client pays at the end when they're satisfied. And the reason we like it this way is you're in control. And if you're in control the whole time, that's the best place for you to be. And if we're here to serve you, and that's the best place for you to be, then we feel it must be the best place for us to be. It just makes sense. So my agreement says, unless and until you write us a check, you owe nothing to the firm. You're free to walk away at any time. Well, what do you think that does? It makes us work very hard to make sure that you're satisfied, and we really do. I think we do a terrific job in getting the thing done and putting it into effect. It's one thing to do the paperwork, and I think our paperwork matches up with anybody's. I haven't seen better, and I see a lot, but I think where we really shine is we make sure the job gets done to the end. You ever hire a contractor and getting them to do the last 5% is just such a bear if you get them to do it at all? I know that. With us, we don't put you through that. We do it 100%. There's no loose ends. That's just how I believe in practicing. So you come in for your you said, okay, we want to go ahead. You come in for the final meeting. We review the documents, explain everything to you. You sign, and generally the clients are very happy. I would say almost universally. So, and you know what? If the client's unhappy with anything, we said we'd be happy to fix it, no charge, even after they left the office. I had a client last month, left the office, signed everything, daughter signed, trustee, everything. Calls me up a couple of weeks later, says, I didn't want my daughter as trustee, we tried to express that to you, but you weren't listening. I said, I mean, a very strange call because everybody signed everything. So, obviously agreed to it. I don't recall them having objections or wouldn't have done it, but okay. I didn't argue with him. I said, you know what? Come on in. We'll redo everything with the people you want. I'm sorry for the misunderstanding. And I've advised our attorneys, and I'm very proud to say, whenever there's a misunderstanding, we take responsibility for it, we fix it. And if we ever make a mistake and we do a volume of work, so mistakes can creep in, our policy is stop everything, fix the mistake first. And we do it at our time and our expense. Doesn't happen often, but you can be sure we're going to fix anything that goes wrong right away. It's first priority. We accept credit cards. Payment could be made at one time, or you could pay it in 3 equal monthly installments, because some people like to pay it out of their income or their cash flow instead of out of their assets. So we're flexible that way. There's no extra fees for that. So now you've signed up, you're a client of the firm. We don't say thank you very much, goodbye. We say welcome to the firm. So we have a trademark process. I publish a award-winning newsletter once a week. I write it. And every 3 years, we'll call you in for a free review. See any changes in your health, your assets, your family, births, deaths, marriage, divorces. Nobody else will offer you a free review every 3 years. In fact, when I tried to explain it to other lawyers, they don't understand the word free. Well, I made it free from the beginning because I realized one thing. If I charged, some people would come in, some people won't, and then some people have a plan that's being kept up and some people won't. I didn't want to have 2 tiers of clients. We said, let's call people in. It generates enough work to pay for itself. People need changes, or people need Medicaid, or people die, of course. We have a state administration more likely to use us if we have a relationship than if we don't. So it's been good for us, good for the clients. This is not the standard in New York, by the way. The standard in New York is just the opposite. I was at a meeting of the Bar Association. I was at a CLE, Continuing Legal Education, a few years ago. There was a panel of experts, ethics counsel, elder law counsel, defense counsel. And they actually told me that the assembled group, after the client signs an estate plan, you should send them a letter. And in the letter, you should tell them that you appreciate their patronage and that this concludes your representation of them in the matter. And why do they want you to send the letter? Because if you send the letter, it finalizes the representation and it starts the clock running on the statute of limitations. So if you made a mistake, they can't sue you. Isn't that wonderful? Who does that sound like it's good for? Well, the concept here is the way lawyers are trained and the way lawyers think is the lawyers are worried about the 1 in 10,000 clients who's going to sue them. Well, I'm more worried about the 9,999 that aren't going to sue us. So I don't follow that advice. I think it's nonsense. I don't believe estate planning is a transaction. The bar thinks it's a transaction. No, it's a relationship. And it's much better if it's a relationship because we're going to monitor it, we're going to maintain it, we're going to review it every 3 years, get to know each other better, go through the ups and downs. So I'm not worried about cutting off my liability. I'm insured for liability. So I think there's a much better system. And I can tell you that this has made an enormous difference in many people's lives. And an Ettinger plan, oh, we don't charge for phone calls, emails, or questions. Why? We want you to communicate with us without a word. I tell clients every day, it's no bother. Call anytime, it's no bother. And I mean it. We're glad to hear from you. But the key here is by using this program, your plan is never more than 3 years old. That's designed to work when you need it, not when you signed it. How many of those plans you think that those lawyers do that they say, thank you very much, goodbye? How many of those plans do you think actually work? I mean, I can't even understand it. I mean, I care that my plan works. I have a lot of pride in it. That's why I make sure it's up to date. I mean, I can't even imagine doing a plan and hoping that it's going to work for somebody 20, 30 or more years down the line. It just doesn't make sense. But again, we have a higher standard. That is that simple. So the no-cost consultation, it can be with me if it's in one of the offices. I work out of Rockville Center, Lake Success. I'm in Huntington. And I go to White Plains in Staten Island. That's as far as I go. I have excellent attorneys. My wife is an excellent attorney. She's runs Melville and Islandia. Um, we have excellent attorneys, all trained in the same system. You get the same representation. Um, we're throughout the Hudson Valley and Albany and Westchester, Rockland. So it'll be with myself or one of our other experienced elder law estate planning attorneys. We have, I just want to say, excellent staff. I have an expression, I say, we hire for character and we fire for character. Uh, we really have an excellent team and we believe in excellence, and it runs through the organization. If you do business with us, it's going to be clear, no matter who you deal with, no matter what office, what person, they're going to be excellent at what they do. The consultations, I prefer them in person because, in person is more personable, right? You feel more comfortable, you get to know each other better. It can be by Zoom or by phone. Um, Sometimes people want an initial by Zoom, but eventually you have to come and see us. But we can start out the other way if it doesn't work for you to come in. You just call the 800 number and it'll prompt you. You can make an appointment or visit us at ettingerplan.com and do it online. Our website is extremely informational, hundreds and hundreds of pages, every particular topic you might be interested in, hundreds of articles. You can learn, and videos. You can learn a lot on the website. So I'll ask you to do that. I'm going to now stop the share. Stop the share. There we go. Um, we have 7 questions, which we're going to answer. But give me 1 sec. I want to grab some questions off the printer as well that people sent in ahead. Be right back. Okay, we have these. Now, let's look at the questions that people raised today. Um, Okay, Heidi says, yes, I can hear you. Thank you. Thank you, Heidi. Anonymous, can you talk about um, Schedule K form? Can a trustee file this form? I think you mean the K1. So on a Medicaid asset protection trust, there's no tax. It all passes through the individual return. So the Medicaid trust files a K1 saying we're paying all the income out to mom or dad. They'll pick up the tax on their individual return. So it's just a form. The trust doesn't pay taxes. Anonymous. Does one need to have a trust to move one half of the assets to nursing home doorstep? No, no. The half the assets of nursing home doorstep is when somebody comes to see me the day before mom has to go into nursing home or the day after, and they say, "What can we do now? We didn't plan ahead." So the one half is for people who didn't plan ahead. They don't have a trust. If you have a trust, you can save the whole thing. Anonymous, I'm 50 years old and my too young to have a trust. The answer generally would be yes. I would probably do a will for you. Um, uh, um, and remember, we review it every 3 years. When you need a trust, we'll do a trust. But if you have property in 2 states, might make sense to have a trust. If you have other issues, health issues, might make sense to have a trust. If you have over 7.5 million in assets, you have a taxable estate, you may need a trust. So, but we don't do trusts for people who don't need them. And I'm very happy when somebody comes to see me and they don't need a trust. I'll tell them, boy, am I glad you came to see me because I won't do a trust for people who don't need it. It has to be cost effective. It has to be, the value has to be there or we won't do it. Because, trust can cost you, you know, 6 to 10,000 or more. Is my book on the website? You can download it on the website. You can order it on Amazon, on Kindle. Yes. The answer is yes. If you use a law firm to administer the estate, how to make sure it's done correctly, or who can make sure there's no hanky-panky going on, especially after you're gone. You know, you just have to pick somebody you trust. The beneficiaries could bring an action if they thought something was wrong, but generally, you pick people you trust. This firm has been around for 35 years. We have about 450 reviews on the website, 4.9 rating. You know, uh, you have to pick somebody. So, um, I'm at a loss to answer that. Anybody could steal, but um, you pick somebody who you think won't do that is really the answer. I know it's not really an adequate answer, but it's a question of trust. You have to trust somebody. I tell people it's like the doctor. You're going for heart surgery, and the doctor can explain everything to you, but at some point the doctor puts a mask over your face and you're out, and you got to trust the doctor. Otherwise, it's not going to happen, right? So that's my answer to that. Barbara, why have a will at all? What is the advantage of revocable trust versus a non-revocable trust? Well, you get a will with a trust called a pour-over will, P-O-U-R, because in case there's a loose end, it's something you forgot to put in the trust or you didn't have a beneficiary, this will put in the trust after you're gone, called a pour-over will, pours into the trust. But you need to, let's say you died in a car accident, the other guy's responsible. We want to bring an action for wrongful death. We need an executor. The will provides that. Okay. Uh, Revocable trust, you're in charge. They avoid probate. There's a plan for disability. They don't protect assets from long-term care. That's the irrevocable trust. Somebody else is the trustee. Limit yourself to the income only. Barbara also asks, with current rules for Medicaid, um, and I put the asset in the trust, I can't control that money. I think you can control the money. You can gift it and you can trade it. I can only work with a small amount not gone into the rest. The rest of my income, not in the trust, goes to some group, usually nonprofit, who gets assets of my debt. Barbara, you're talking about something called the pooled income trust, and that's only to protect your income, not your assets. And there's only a small amount left that you didn't spend when you die that goes to the other trust members. It's chapter 50 in my book, but it's only for home care. So if you get a chance to come in, I'll explain that further. Heidi, at what age do you think a trust is a good idea? Well, certainly 65 plus, but earlier, if there's a tax issue, property in more than one state, a health issue, etc. Let's see what else we have here. Hello, Barb. Um, why not need a trust when younger than need it older? Because um, trusts are more expensive than wills. And a trust starts to make sense when you get older because a trust is a plan for disability, which the risk goes up when you get older. When you're young, the chance of disability doesn't merit the cost of setting up a trust. So we use a will because, of course, you could die. It's unlikely, but you could die. You'll have a plan. Yes, it has to go through probate, but still, uh, being younger, you don't get the value of doing a trust because you probably won't use it. Janice, hello. This was a wonderful presentation. That's very nice of you. Thank you, Janice. Quick question. Can I add properties after my trust? Of course. You can always add to the trust. Now, if it's a Medicaid asset protection trust, remember there's a 5-year look back. So if you add to the Medicaid trust, it's 5 years on the new money. Anonymous, how about if the person living in Washington, can you administer the estate? No, you need a Washington lawyer because the rules of administration are governed by the state where you live in. Okay, now I'm going to the ones that were sent in. Peter says, I have no one named as successor trustee to my revocable trust. This needs updating. Can Ettinger offer these services? Yes, we do. We do act as trustees for people who don't have someone else. Diane, I'm 82 years old and have a revocable trust. Can I change it to an irrevocable trust? What is the difference? Would it be beneficial to change it? Well, I think you know the answer, Diane. Um, the irrevocable trust will protect your assets. There's a 5-year look back, but even though you're 82, which is not that old even these days, remember it prorates. If you need care in 4 years in a facility, you only have to pay for one. It always pays to get started with the irrevocable trust. You'll decide what you want to put in. Um, Beverly says, I'm considering a trust. My attorney is New Jersey. I understand I need a New York attorney for a trust. Yes, you do. That's correct. If you live in New York. Let's see. Do life insurance, Joseph, do life insurance contracts need to be in a trust? No. but you want to name the trust the beneficiary of the life insurance so it follows the terms of the trust. Here's Jacqueline says, I have an irrevocable trust. I want to change the beneficiaries from 3 equal shares for my adult children to one of them and her 5 children equally. How do I do this? That's done by an amendment. Certainly, if it's an Ettinger trust, I know can amend it. If it's not, I can have to look at the trust and see if it's possible. You can bring it in. We'll look it over. Stuart, okay, understanding how a living trust works with an investment property and LLC. We take your LLC interest and we put it into the trust, not a problem. Amy, can I put my Fidelity non-IRA into the trust? Sure, we do Fidelity all the time. We even have the form. We could fill it out for you. How do you, Aleli, how do you use trust as beneficiary of insurance policies? You change the beneficiary on the insurance policy to the name of the trust. Liz, how does a trust disperse assets? Do they need to go through probate if you have beneficiaries? Assets that have beneficiaries don't go through probate. A trust is really names beneficiaries. So when you put in the trust will distribute the beneficiaries you named. How much, Jenny, how much to put into a trust? Well, that we have to meet and go over, depends on your assets. Do you need the money? What do you need it for? Okay, here's Barbara's written in. If they have beneficiaries, correct, they don't go through probate, brokerage accounts, savings accounts, IRAs, money markets, okay. The home you own jointly, can you put your portion to a trust? Yes, you can. You can put half of a house into the trust, your half, okay? Not a problem. Let's see if there's anything else, okay. I set up my adult children to be executors of the trust. Do I need an attorney to make sure they adhere to my wishes? That's George. Well, they won't be able to probate the will without a lawyer. And the lawyer, if you have 3 children, they're fiduciaries. They're liable. It's it's criminal to take the money and not follow the terms of the trust. So I don't think that there's too much to worry about. Wing says, can you assign your kin as executor trustee? Sure. You can name your children as executor or trustees. Oh, that's it. Okay, we have managed to get through it. Now let's see if anybody has asked any more questions. Stefan says, great presentation. Thanks. Thank you, Stefan. That's very kind. In preparation of making a trust, do we first need to make sure we have joint accounts, updated beneficiaries, and such, or will making the trust? No, you don't have to do anything. First, if it goes into the trust, beneficiaries automatically come off because any account in a trust, the trust has the beneficiaries. There would be a conflict. So, when you come in, we'll tell you, you may want to tidy up your affairs, close out the small accounts, combine what you can, because that's just good estate planning. But there's no need to do it before you meet with us. It can be done at any time. So, I want to thank you all for coming and thank you for listening, and hope to see you all in the office very soon. So have a good night, and we'll give the seminar again a month from now. Meantime, happy Thanksgiving to everyone, and we hope to see you soon. Roseanne, you're coming in under the wire here. Thank you, Heidi. I appreciate that. Roseanne, give me an email or a call. I'm going to say goodnight now. Thank you, everyone.